Court does call the case, People versus Matthew Wright.
If you ever make that for people.
I'm sorry? Oh. Sure.
Oh, Matthew Wright.
Thank you.
Sorry.
It's all right. What are we doing?
Your Honor, maybe approach me really quickly.
That's how you want to start my day?
Mm-hmm.
Fine. Fine. You're not asking. Jerry says I'm not asking. Yeah, come on. All right. Record to reflect at a bench conference.
Hey, Your Honor, this is an exact set of preliminary exam. I did explain to counsel that it appears we are not able to proceed at this time. We anticipate that we may be able to, once we can get a hold of the defendant witness in this matter. And we will be authorizing the case promptly as soon as we can.
Move to dismiss, Your Honor.
People being unable to proceed this case.
Balance scale case dismissed before it even starts. What has happened here? In legal terms, this is called a dismissal for lack of prosecution, meaning the state couldn't bring witnesses or evidence in time. For the defendant, that's like walking out of court scot-free before round one even begins.
Case is dismissed. That is on defendant's motion. Thank you. Court does call the case, People versus Leon Booker.
Alexander, on behalf of the people, Your Honor.
Oh yeah, hours ago. But don't worry about it. No, I thought you were here all day. Yes, it has. Thank you.
Your Honor, at this time, people are people are unable to proceed under count one. I would ask the court to remand count two to district court.
The brandishing in public.
Correct, Your Honor.
All right. So I'll dismiss count one, maintain the plea of not guilty as to count two. This matter will be set for pretrial 1482 District Court on
April 30th at 9 a.m. before Judge Barr.
April 30th, 2025, 9 a.m. before Judge Barr.
Thank you, Your Honor.
All right. Thank you. And we'll continue. Court does call the case, People versus Demetrios Mastopoulos.
Alexander,
Why are you laughing?
Your Honor, Joe, on behalf of defendant, state your name. Demetrios Mastopoulos.
Okay, I got everything but one syllable in there. I was close. All right.
Your Honor, today's the date and time set for preliminary examination. At this time, I would ask the court to amend count one to make an attempt interfering with electronic communications. And then we would ask the court to remand on counts 1 through 4 to district court.
Okay, I'm not going to be able to do it that way.
After count one.
I have to, yeah, because what has to happen is count one would be dismissed. And then he would go down to on counts 2, 3, 4, and 5, which would become the attempt. I'm going to need the PAC code on that one. It's likely going to be 750, 540, 5A with a bracketed A.
Correct, Your Honor.
Does anyone have any objection to that?
No, Your Honor. Thank you.
I would order that the people are to file an amended complaint in the case so that everything is clear.
We'll get that out to you.
And as to count 5, your client is standing mute to that charge.
Thank you, Your Honor. Yes.
And the court will enter a not guilty plea. Maintain his not guilty pleas to counts 2, 3, and 4. Count 1 is dismissed. I will set a pretrial before Judge Freshour, April 24th, 2025, 10 a.m.
Your Honor, can I ask a quick question? Is that here?
Yes, it would have to be. It's here.
Right. That would be greatly preferred. It's a DV. She likes to hurry the DV docket, but this is a client who's already been to court, been admonished on his bond conditions. That's what she likes to do, and I'm not criticizing that. I'm just stating it factually.
So May 6th, 10 a.m. before Judge Freshour.
Thank you.
Bond will continue. Court does call the case of the People versus Derek Graham.
And is that on behalf of the people, Your Honor?
All two.
During on behalf of the defendant, both matters.
Thank you.
Your Honor, today's the date and time set for preliminary examination. At this time, at case 24 FB 1431, the people are unable to proceed as to count one, as that count 2 be remanded to district court. And in case 25 FB 1109, people would ask the court to add count 2 of misdemeanor stalking. The PAC code 750.411H, and we are unable to proceed as to count 1. Would ask that count 2 be remanded to district court.
With regard to, and apparently I have the case numbers reversed, but it doesn't really matter at this point. In both matters, Your Honor, I ask that the felony charges, count 1 in both files, be dismissed.
All right. In the case ending in 1431, that'd be the easiest one for me to do. I will indicate count 1 is dismissed. Continuous plea to count 2 of not guilty. I'll set a pretrial in that matter at 14B for. Before I give you a date on that, let me.
We're going to ask the court for bond on that matter, Your Honor. So if we can just take care of the other matter, we can address both cases.
All right. And so dismiss count 1. You're adding misdemeanor stalking.
Correct, Your Honor.
In the PAC code on that.
750.411H. It's 1 year, $1,000 fine, 5 years probation.
Just 411.
Correct.
All right. 1 year, 5 years probation. Good.
I'm sorry, Your Honor. My client was asking me a question.
No, it's okay. And so you waive any further formal reading of that and are not guilty pleas to that. All right. Count 1 in that case is dismissed. I'll set pretrial in these matters. All right. In both cases, pretrial will be set April 28, 2025, 9 a.m. before Judge Washington. And as to bond, Mr.
Your Honor, bond was, and I apologize because I forgot to look and see what the bonds are in these matters, but whatever they are, they were set obviously at a time when Mr. Graham had felony charges pending. Those 2 felony charges have now been dismissed. Mr. Graham understands that if the court does allow him to be released, whether it's on a PR bond or a low cash bond, that if he violates bond in any way, those matters could be reinstated. And I'm sure Mr. Graham does not want that to happen because today is a step forward with those cases dismissed. Your Honor, I'll have to ask Mr. Graham, the address I have for him is a Detroit address because that's who contacted me to represent Mr. Graham. I'm sure the court is going to ask if he's released, where he would be staying. And I would ask if the court would consider a PR bond with a GPS tether, no contact, no go-to. I think it would be appropriate in this situation.
I have, just speaking of addresses, I have a Miami Avenue in Ipsy.
So
Miami Avenue in Ipsy?
that would be his home address, Your Honor. I just didn't know what the alleged victim was also at that address.
Well,
She's not.
my no go-to is for Dakota Avenue, so I don't. Is that? All right. Okay. All right. So people's response.
Your Honor, we would object to any modification of we were in contact with the victim as recently as Friday, and she was on board the prosecution. We haven't heard from her today, and we have great concerns as to that.
Flushed face, and here's where things take a dark turn. Prosecutors are about to drop some chilling details, threats, violence, and raw emotion. Buckle up, because what comes next reveals just how dangerous words can become when the court starts connecting them to real-world intent.
But also in this case, we have great concerns given the threats that the defendant was sending to the victim, including threats to shoot her, to kill her, kill one of her kids, saying things, I'm about to kill one of your kids, bitch. As soon as I get my money and buy me a gun, I swear to God. And then the other case, saying things along the same lines of wanting to kill her kids. I swear to God, I'm going to shoot up in that bitch. I'm going to hit one of them bitches in the head. I'm going to catch one of your kids and I'm going to mark their ass. I don't care about going to prison. I can't wait to catch some of your kids. I'm going to kill you broad ass daylight. So I have great concerns given the nature of these threats and given that we have not had contact with the victim today, but she did recently on Friday and that she was on board. We have great concerns. And I also believe he has a hold out of Jackson County for child support as well, Your Honor.
If that's the case, I was unaware of that part. The part about Jackson, that could be addressed if he's released on bond from here. Your Honor, with regard to the threats, I know this court knows it's not unusual in a case of this type for the people to have contact with the witnesses or victims a day or two before when they don't show. This is certainly not the first time that's happened. But all I can tell you, Judge, is something happened to the victim between last Friday and today. It wasn't my client, because he's been sitting in the Washtenaw County Jail. Yes, he may have made some threats. I can't dispute that because I'm assuming those were taken from jail calls. But yeah, when someone's sitting in jail, particularly at the beginning, they get upset. I understand that, but obviously no one's been killed that we know of.
And Your Honor, these threats were from the police report, not from jail calls. They were from what he sent the victim's phone that led to the charges.
So he was out. He was not in custody.
Did you catch that? The defense basically admits, yeah, he ran his mouth, but nobody got hurt. Thinking face, here's the thing. In criminal law, threats don't have to result in physical harm to be serious. The moment intent and fear are proven, boom, that's enough for felony stalking or harassment.
When he allegedly made these threats and nothing happened to anybody. So Mr. Graham doesn't get insulted, was running his mouth. Right?
When he's out, is he working or?
He's been in custody for a while, Your Honor, I assume, so I don't know the answer to that question.
Okay.
Charge set up for April 1st, and I said it recently, and they I had one that prosecutor was Woods, and it was addressed, so it should have been a problem. But I had a job, I was going to start April 1st. No, I think they need to go to bond, but she said she wanted to say after this case.
Right now, his bonds are set at $100,000 cash surety in each case. I'll reduce the defendant's bond in each of these cases, $25,000 cash surety in each case. Defendant must be placed on a tether, which is the previous order prior to any release. Now, I don't know. Oh, okay, they both do. The tethers, as they read, are exclusion zones around the Dakota address. So, sorry. All right. Thank you.
Just one moment. My client seems to think that the bonds are $50,000.
10%
Did they get changed at some point?
The bonds I had originally were both 100,000 cash surety, but were not changed.
He's on 2 felony cases.
And then he has a misdemeanor case of now he's saying that I believe in 14 feet.
So he's
So
reducing
that bond he's referring to. It's 100K cash surety.
Yeah, that's what I had.
That's for the felonies?
On these two cases, I had 100,000 cash surety on each case.
Let's work. All right, Jeff.
All right. Thank you. Court, that's called the case of the People versus Haley Gregg.
In favor to the first people.
Courtroom, please, for Assistant Public Defender on behalf of Ms. Gregg. Ms. Gregg, will you do the podium? Please state your name for the record.
Here we go.
Thank you, Judge. State time set for preliminary examination in this matter. I ask welcome to Mr. Bradley and Ms. Gregg. At this time, the has been offered, would you like to make this second part for the resolution?
Ma'am, is that correct? You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. You understand you'll not have that hearing. You'll proceed to circuit court for further resolution. People also waive the right.
Yes, Your Honor.
Preliminary examination have been waived. Defendants bound over to circuit court on count 1 with 2 following. Mr. Fisher.
Judge, we'll wait for a reason standing.
Defendant have a waive formal reading. Standing mute to both counts. Court will enter not guilty plea. Pretrial will be set for
May 7th at 1:30 before Judge Conlon.
May 7th, 2025, 1:30 before Judge Conlon. Bond will continue.
Judge, I just want to address.
Oh, go ahead.
Thank you, Judge. My understanding, Mr. Duffy, is that Ms. Gregg does not have a full history. Obviously, this case, the allegation is that Ms. Gregg is out of character for herself. She is ready to take responsibility and resolve this matter, hence the waiver. She is asking the right to consider the reduction of her bond and a proper release. She has no problem with the tender. She would have no problems with the tender and following our court orders. In the meanwhile, I'm going to look into possible treatment courts for Ms. Gregg. And she said that she would follow the conditions. I believe she wants to address it. I didn't really want to talk about what happened in this case. Why did you want to talk about? I didn't have why I didn't do like court misstep. I had other issues. But my truck was stolen and my phone wasn't there. I know it's not really an excuse, but I didn't really have a way to communicate with anybody, and I was scared. I didn't know if I've ever been through this situation. I usually, if I get arrested, I find myself out when I come and I pay my fees. And this has been a terrifying experience. I'm not used to any of this for real. I don't know what else to say other than I'm sorry. If I was going on a character, I want to put medication.
So,
Yeah, I've been on my medication.
okay, let me ask you this. You failed to show, the reason she's in is because she failed to show in February. And I issued the bench warrant. So let me ask you this. What happened after you didn't make that court appearance? What'd you do?
Really nothing. I tried to survive out there. I was homeless. What Joe's asking you is,
Okay.
why did you not contact the husband's office or court? I didn't know what to do. Like I said, I was scared.
Okay, that's what you were talking about. Okay.
Mental health proceedings, stuff like that.
Okay. So let me ask you this. How'd you come back into custody? What happened?
Somebody actually told the police where I was at, and they knew that I had a felony warrant. I guess that they came to the hotel, and I didn't know. That's how much I don't know. I opened the door. I was like, "Hi." They're like, "Haley." I'm like, "Hey." They're like, "Yeah, let's go." So I was like, "All right." Yeah.
You mean that's how you were talking to the police?
Yeah. We're okay. We're good. I mean, I don't, the police, they don't really bother me. They know that, they like me, but they don't. This sounds like that this kid was off the medication. It sounds like she's not on her medication. It sounds like she's been in custody. Something you said, I've been here 21 days, 21 additional days. She has no problem with the tablet, 100% necessary. She's hoping you're on to consider at least. There's in fact that she's waiting, it's taking some responsibility, ready to take some responsibility. And it's not resolved.
Any response from the people?
Your Honor, I don't have any objection to her being released. I'm not sure what the situation is now, where she's going to stay. But given that the location, I think, of the underlying incident was around the Banana Center, she mentioned she didn't have stable housing. So if there is a tether order, a GPS tracking tether might be appropriate.
Well, I'm not gonna put her on a tether. She has enough problems trying to find housing and put a roof over her head.
I mean, the honest that I did have, I was there
And then you're gonna have to get back on the list to get, I know how it works.
I am, that's why I was so upset with myself. Like I'm in the house, like the housing list, you know what I'm saying? I don't know how this all works. He knows how it works. And so he understands the difficulty you're gonna have trying to get back into something for the sake. I'm gonna stay here. That's not what he said. Oh, I don't know. I'm terrified right now. I'm shaking.
You're what?
I said I'm just terrified. I've never.
You're shaking right now?
No.
Why? Do I make you nervous?
No.
Why do I make you nervous?
It's the high bench.
Yeah.
Is that what it is?
It's the height for me, sir.
Oh, okay. I'm like, such a kind and gentle soul. I don't know why.
This moment right here is why courtroom videos fascinate us. The unexpected humanity amid all the tension. The judge cracks a joke, laughter breaks out, and suddenly the atmosphere lightens. But don't miss what's underneath: compassion and accountability. Speech Balloon, what did you think of how the judge handled this one?
Whoa, whoa. Emily didn't have to have that response. Wow. 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 Alan, you could have stuck up for me. You could have. No? Wow. Everybody's just turned on me. All right. Miss Gregg, here's what I'm going to do. I'm going to reduce your bond. All right. In this case, I'm going to reinstate it back to what it was, to a $15,000 personal recognizance bond. Now, in doing that, Ms. Gregg, you got to make sure your next date is the 7th. You make sure you get there. You hear me?
Yes, sir. Yes, Your Honor.
Okay.
That face.
You didn't even think that would happen, did you? Okay. You get out today. You're welcome. Take care of yourself. Wow. She did better than you.
Thank you, Judge.
Alan wasn't going to do anything. He just, see, Alan, he's so hard. Wow.